Well, hello, my friends, classmates, friends, countrymen, ladies and gentlemen. We are doing bioethics, and we're doing chapter 5 in your Vaughan text. This is on informed consent, and it is very short on the instructional side, very straightforward. This will be a very brief video, at the end of which we will look at the additional reading that I've chosen for you, which is the court case, very famous court case, Canterbury v. Spence. And we'll talk briefly about that. You'll have a question on your quiz for this chapter based on that. So you'll want to be sure that you read that carefully. So let's talk then, first of all, about the instructional text. And we are at, let me pop over to the beginning of the chapter just so we are all on the same page. It's page 196. And we are going to be talking about, well, let me get the presentation started. You can tell I'm super prepared today. And there it goes. Ho ho! All right. And I'll be down here in the corner being a goof. Great. So let's talk about the first part of your text, which is about 10 pages of instructional text. All right, so just so you are keeping track of these things, the key terms to take away and to make sure that you know, I need you to know these terms for the quiz, are competence, informed consent, therapeutic privilege, and waiver. Okay, so we're going to talk about each of those. The last two, therapeutic privilege and waiver, go together. But you really need to understand the key term competence and then informed consent, which is of course, the title of the chapter. So I need you to know those things when we get through this little discussion. All right, so let's look first of all at the definition of informed consent. It is defined as the action of an autonomous, informed person agreeing to submit to medical treatment or experimentation. Okay, so we have some really important terms there. I've already mentioned informed consent, of course, is that key term for this section, but you also, in order to understand that, need to understand that concept of autonomy. And the idea of autonomy and being informed will go together, as you'll see, as we unpack this definition. Okay, so then we have the key here, though, is that informed consent is an action. Something one does, and in particular the context of the action is in medical treatment or in human experimentation. And so the idea is that the action is in particular an agreement. You are agreeing to undergo medical treatment or participate in an experiment. And you have to be, though, in order for this to be a morally legitimate or ethically sound agreement on your action, or the action would be deemed that there are certain conditions that have to be met. And so we're going to unpack then this idea of the autonomous informed person. Okay, so what are the conditions? There are 5 of them. First of all, and we're going to go, by the way, into each of these into more detail. I'm just going to present them here, and I've highlighted what I think are the key terms in each of these conditions so that you can sort of focus your understanding of the 5 conditions on those terms. The patient, first of all, is competent to decide. Now, that was also a key term that I mentioned at the beginning that you will need to know. We'll talk about that. She gets an adequate disclosure of information. And so this process of disclosure is important, but also that word adequate is super important. That's what actually is raised in that Supreme Court case, Canterbury v. Spence, is what really counts as adequate. So we're going to be talking a good bit about that. Third condition is that she understands the information. So not just the information is given to her, but then that she is able to process it, understands it. That's a condition for there to be informed consent. Fourth condition, she decides about the treatment voluntarily. In other words, she does it of her own free will. She is not coerced or manipulated into it. And fifth, finally, she consents to the treatment. In other words, this is the act then that follows. she actually does agree to do it, and that then if all these 5 conditions are met, we would say that the patient has been provided informed consent, or that the patient has made a choice based on informed consent. Okay, so let's talk about competence. This is an important term. So competence is the ability to render decisions about medical interventions. Okay, so notice that we have here some sort of ability to decide. Okay, so that means it is some mental activity in particular, or mental capacity, and that you are in a position of understanding, as we see in the 3rd condition. But the idea is that what does it mean to be, let's take the opposite, incompetent? That means unable to do something, or you lack the skills to perform some act. Okay, that is incompetence. So in the case of competence, then you do possess the skills, or you do possess the ability, in this case, to render decisions about medical treatment. Okay, so now what would be some examples of individuals who are incompetent? Well, we can think of people who might be unconscious. And you can't obtain informed consent from an unconscious person. They do not have the ability to render a decision. Maybe a very small child, for example, who is unable to decide of their own, in any sort of rational sense of the term. There would be maybe the case of someone who is suffers from an emotional or mental disability. So they too may lack the ability to render a decision about their own medical treatment. Okay, so we can think of counterexamples to competence. A person is maybe a degree of incompetence. Okay, and notice that this is a ability that can come and go. It can wax and wane. You could be incompetent at one stage of life, competent for maybe most of your life, and maybe at the end of your life you would be incompetent. Maybe you're in a coma, or maybe you're suffering from a condition like Alzheimer's, where you aren't competent to render an informed decision. Okay, so now let's talk about the law and informed consent. This is unpacking the concept of disclosure, okay? And we're going to, again, talk about that with Canterbury v. Spence and the idea of adequate disclosure. All right, so let's talk about what is mandated for disclosure, and what has to be disclosed in order for there to be informed disclosure. In order for there to be adequate disclosure. First of all, one has to be told the nature of the procedure. Second, we have to be told the risks of the procedure. Third, we have to be told the alternatives to the proposed procedure or recommended procedure, including the option of no treatment at all. The fourth aspect of disclosure is the expected benefits of the proposed treatment. Okay, so you've got those 4 aspects or parts of disclosure. Now, the adequacy of that disclosure is another element. We're going to talk about that in Canterbury v. Spence. All right, now next is we're talking about the understand. We have to be able to understand then. So there is the disclosure part where the information is given, and then what about processing that information? What does it mean to understand that? Well, one of the things that has to be in place is a decision-making capacity. Okay, and that's something that it is incumbent upon the medical professionals to assess whether that is present. So it involves determining whether a patient or subject is psychologically or legally capable of adequate decision-making. Okay, so that's connected to that idea of competence, would be one element to it. But also there might be a psychological There might be psychological factors involved as well, where the person might be competent, rationally speaking, but is, has this a current state, is in a current psychological state that it renders them unable to be in a decision-making capacity. Okay, and then let me see if I had anything else. So this capacity then relates to the specific medical decision at hand, and it doesn't imply a global ability to make any and all decisions about healthcare or other matters for that matter. It just has to do with the specific treatment intervention that is under consideration at the time. Okay? So you don't have to look at all other aspects of the capability to make decisions, to get a good job or something like that. We're just talking about the decision-making capacity when it comes to medical treatment. Okay, so that is the key idea, that the individual possesses that. What does that look like when we're talking about understanding the information that's disclosed? Well, what it means then is that if you think about what goes into making a difficult decision, you're taking information in, and that information has been disclosed, and then you consider it. You weigh the pros and the cons and the options. That is a process of deliberation about the choice that you need to make. Okay? And so that is, those are indications that you understand, that you can process that information. So things like being able to weigh and consider the alternatives, to the one that's recommended, for example, to deliberate about, what are the implications beyond just making this choice, what follows from this. Those kinds of things would indicate your understanding of the information. Okay, I want you to be sure to look at the section on starts on page 199, goes to page 200. It's a dive into this idea of decision-making capacity, and there's a lot of good analysis of that, unpacking of that, where I mentioned that what this is talking about is it's not some abstract or subjective report of, hey, yeah, of course I've got decision-making capacity. No. What this means as a condition for informed consent is the responsibility is on the medical professionals to assess this. And so this in-depth discussion here on pages 199 to 200 goes into how that is done, practically speaking. It talks about the relevance of this decision-making capacity, and who decides whether the patient has it or not, and why it is not always for example, the patient might be under the care of someone else, or be under the guardianship of someone else, and so there that's a slightly different situation where who's making the decision. And then on page 200 more details about questions to ask to determine whether a patient has decision-making capacity. And then some unusual and exceptional cases are considered as well, things like mental illness and religious beliefs as well. So have a look, please, at that section. It's very helpful for unpacking this really important condition for informed consent. Okay, so if individuals lack, and I apologize for my screen here, I think it might not actually be showing you. Let's see if I can move the doohickey. Sorry, talking to myself. No, I didn't mean to do that. Here we go. Let me just bump this over. Hopefully now that shows up a little better. And all right, so let's continue to unpack this. If individuals lack decision-making capability, they may make decisions that are contrary to their best interests, and thus they need to be protected from harm. So that's why, in fact, the nurses and the physicians need to be involved in this assessment of decision-making capability, is they have these duties as caregivers to provide beneficial care and not cause harm. So if decision-making capacity is intact, the physician generally should respect the patient's choices. And so there, we'll talk about this in just a moment, this potential ethical conflict, when two ethical principles come into conflict. In one case, the autonomy of the physician and to implement the best practices as understood by their profession versus the autonomy of the patient to make choices about their own healthcare. Okay, so let's talk about then exceptions to informed consent. Of course, there are emergencies where life is at stake. There's no time allowed for this sort of process to unfold. Second is, of course, the incompetence of the patients. We've already touched on that. You don't seek informed consent from a patient who is not competent to provide it. And then we have the other key terms I mentioned at the very beginning, a waiver. So a waiver is an exception to informed consent because that is where the patient may voluntarily and deliberately give up the right to informed consent. So a patient can waive that decision-making ability to have the final say, and there might be good reasons to do that. And so, like they may want to leave things into the best judgment of the physician, for example, or they may want to pass the right to make those choices to someone they anticipate, being able to look out for them, their welfare better than they can look out for their welfare themselves. So there are different scenarios in which the waiver might be used as an exception to informed consent by the patient. But this is patient directed. This is something that comes from the patient's choice. Okay, and there's that key word voluntary there. So again, it's not something that's coerced or manipulated. And the idea that a choice is voluntary suggests that it's possible to resist, factors like external suggestions and stuff. So that is what is important here, even in the waiver, that they're not being coerced or manipulated into handing over this exception to informed consent, their right to it. But they have voluntarily done it. They've deliberately done it. It's not an accident. It's like, oh, I signed the wrong form. Okay, so there's the waiver, and then finally therapeutic privilege. And this is where if a physician believes that disclosing some information would likely do harm to the patient, then the physician invokes therapeutic privilege to withhold then that relevant information from the patient. Okay, so there is this is an important one, and it's the point at which I mentioned earlier that there are two duties that might come into conflict here. First of all, is the duty to respect the autonomy of the patient and provide informed consent. So there's a duty to seek informed consent, but then there's also the duty to beneficence. There is the physician's autonomy as well, and nurses as well, and always seeking what is in the patient's best interest sometimes may cause them to withhold information from the patient. Okay, so therapeutic privilege, and this should go without saying, is a very controversial position. It is not always permissible and not always allowed. So there are arguments where that should be something that a physician could always invoke, but that is not globally accepted. So this is one of those sort of gray areas where there is debate, pro and con. And there's a good article, if you want to dig into that, there's a good article on this subject in the additional readings. I didn't assign it though. And then here's a list of some of the major court cases that had to do with informed consent. You can see interesting history starting in 1914 and going through 1972 is Canterbury v. Spence, and we're going to look at that one in particular. That's your assigned reading from this section. Okay, and as I mentioned in the introduction to this video, that the really key idea is adequate disclosure. So we've talked about disclosure, the things that have to go into disclosure, the nature of the treatment and the alternatives to the treatment and so on. But what constitutes adequate disclosure? That is what was under consideration by the court. If we look on page 235 for the reading here, we see that if we're looking for a standard to say, oh yeah, okay, that informed consent, or I'm sorry, that disclosure was adequate for informed consent, what would that standard be? And the judges decided that adequacy is not what the medical profession thinks is appropriate, but what information the patient finds relevant to a decision. And that's the key, is it's looking to what information the patient needs and desires in order to make the decision. So what is relevant for me to make this, to act in an informed way about my own medical treatment? I will tell you the relevant things to me, okay? And that's what has to be respected. That's what has to be present for there to be adequate disclosure. Okay, so the quote here is from the case is, okay, so what is this, what communication has to be given? It must be measured by the patient's need, and that need is the information material to the decision. Okay? And so it is incumbent then upon the medical caregivers to seek that out from their patient. And by the way, this is why you have to have decision-making capability. You have to be able to communicate this need to the medical professional. What is it that you find relevant for making a decision? If you're not sure of whether to go forward with what the physician recommends, what do you need to help make that decision? Okay, that's what has to be sought out in order for the decision then to be one that is that meets the standard of informed consent. Okay, so have a look at that case. You'll have a chance to respond you'll be able to write a brief essay on that for your quiz. And that's it for informed consent. And I will see you next time. Again, Dr. Joel Hunter, Bioethics, Informed Consent, Chapter 5 in Vaughan text. And I'll see you next time.